bring up my so I got Virginia, North Carolina, and New York and Minnesota. Okay. So what's it again? Virginia, Tim? I mean
Yeah,
Virginia, Kyle.
yeah, Virginia.
Tim, you're New York.
Yeah, well, I got two cases. I got one in New York and one in North Carolina. So, um, but yeah, I'm in both states. Got cases in both states, New York and North Carolina.
And by the way, you want to always move to your state when you're looking for information, unless it's of course from the United States Supreme Court and they spoke on that issue. Then you know it blankets everything. But there we go. So in Minnesota, there's the modification and determine. Uh, we don't care about modification. Go directly to the guidelines. While the guidelines may call for custodial cases, they are only guidelines, not mandatory. That's kind of scary. Uh, but I want to find what that means right there. So let me on one of my let me open up my so I can we can pull up the cases. So I'm having to use my screen from pull that up. And let's go back down further. Minnesota. Oh, there you go. You see that, Minnesota? Oh, we there, Dale?
Sorry, I was speaking on mute. Yeah, I see that. 1986.
Not gonna let me open it from here, but I'm
Can,
about to get you in here so we can open it up. Um, so now we can take you out, Minnesota, so we know we can find it from you. We got up here now. North Carolina. See that?
Yes, sir. I'm still here.
No, you see that? Can y'all see the y'all see this? Is your screen moving too?
Yeah, it
yeah,
is.
I can see it.
Okay, so we took care of Minnesota, North Carolina. See that? On the consideration of evidence before it. So it's within the discretion. That's scary. Absent a showing of abuse of that discretion, it won't be disturbed on appeal. Okay. That discretion. I don't like discretion. We want to make sure that they have to have something substantive. Discretion means they can do what they want to do.
That's right. They got a wide range of discretion here in North Carolina. That's the dilemma.
Yeah. Now Virginia has an interesting one too. This is to modify. That's change a certain when child court for the child support, the amount as determined according to the statutory child support. Okay, there you go. You see that, Virginia?
Yeah. When a trial court sets child support, the amount as determined in accordance with the statutory support guideline procedures set forth in Code 2108 is presumed to be the correct amount. Any child support award, whether it is the original or modified award that deviates from this presumptively correct amount must be supported by the trial judge's written findings.
But you might want to go down here. Keep going. Keep going.
All right. The judge's findings must explain why the amount according to the guidelines would be inappropriate or unjust and must justify the amount of support awarded. And then those are the case law. The findings that rebuts the guidelines must state the amount of support that would have been required under the guidelines, shall give a justification of why the order varies from the guidelines, and the deviating amount shall be determined by relevant evidence pertaining to specified statutory factors affecting the child's needs and the parent's ability to pay support. Okay. Um, the trial court order reducing Bobby Miller's support obligation fails to explain why the guideline amount is unjust or inappropriate, fails to determine the guideline amount, and fails to give a written explanation for deviating from the guideline amount. The failure to make the required written findings in accordance with Code 20-108.1 and 108.2 was a reversible error.
That makes you feel better, right?
Yes, sir. Yes, sir. I just got that written down too.
I'm about to send it to you.
All right, cool.
I'm sorry, guys. If we're having issues because I'm opening windows and now I'm realizing that opening these windows causes problems because of the lack of memory on the machine that I'm using. But I'll get that fixed within a week or so. But hopefully everybody's getting enough of the substance from what we're talking about. And then I'm about to put this inside your inbox, inside the what you call it for you guys. So I'm in Virginia, so let's do it this way now that I'm here. So let me do this, and then we do this, and then we find you see the 20 cases at the top now? At the top,
Yes.
this is your case right here. So, and I can do, how do I do this thing again? Chat.
Baxter.
Check your chat room. You just see that, Virginia?
Yep, I got it.
Okay. Now we're going to, what's the other state we were just in the first time?
Minnesota was the first one.
I already pull it up. There's actually a number of case laws I can see.
Okay, so you can see them.
Yep.
Yeah, and I tell you what, this is the greatest resource and it's the most affordable, much less than what the firm has, but it does well. The firm stuff is great too because I can do other things. I don't tend to bother with it when I'm on these things. But see that? So now we gotta get. I don't like this issue about I don't like this right here. You don't want to see this. You know why Minnesota? You don't want to see this?
Because they could do whatever they want, basically.
Oh, there you go. I'm not going to apply to all custodial cases.